Mr Speaker, I too am very pleased to see the final reading of the Trans-Tasman Proceedings Bill. It certainly has been something that has generated a lot of work between the two countries, and it was able to be signed. I think it was the 28th anniversary of the signing of CER that saw the agreement on Trans-Tasman court proceedings and regulatory enforcement signed. And I made the point during the first reading was that I was the one who had the privilege of signing that agreement on behalf of the New Zealand government, and it certainly was a privilege to do so because it really was quite groundbreaking steps that we were taking as a country and as two countries actually, having the confidence in each other's judicial and regulatory institutions in order to sign off on such a significant piece of work. The legislation itself, of course, follows on from not only the signing of that agreement. That agreement was in fact preceded by a significant amount of work that was undertaken by the working group, represented very well on both sides of the Tasman. It was interesting. I found an article that was written at the time of the signing of the treaty by the Australian Attorney General Robert McClelland and myself back in 2008. And this particular article said that the signing of this treaty, once it was implemented by legislation, and the comment was made that its advent will make life a lot easier for businesses which now face a time-consuming and expensive process when dealing with Trans-Tasman legal issues. Under the existing law, fines and civil penalties imposed by New Zealand courts cannot be enforced in Australia and vice versa. Prosecutions under Australian law cannot be brought in New Zealand and vice versa. Criminal proceedings initiated in one jurisdiction probably cannot be served in the other, although no one is absolutely sure about this, but civil penalty proceedings in most cases can be. Orders made under regulatory laws in one country are not applicable in the other. What all this means is the moves made over the past 25 years towards Trans-Tasman harmonisation of competition, consumer and other laws meet an abrupt brick wall when parties seek to utilise the enforcement might of the courts. And it is the abrupt brick wall that we are in fact breaking down with the legislation that we are passing today, and that I think will be of significant benefit to businesses and individuals on both sides of the Tasman. I also reflected during the committee stages on a contribution made by the law firm Chapman Tripp in relation to concerns that they had raised with respect to this departure or potential departure from the long-standing rule that domestic courts do not enforce penal laws of foreign states because to do so is contrary to the principles of independent sovereignty. And I thank the Minister for addressing that issue in his third reading speech. Unfortunately, he didn't manage to do it during the committee stages, but he did touch on it in his third reading speech. He may not have been aware that he was doing that, but he did answer the question about the significance of that change and why the government had chosen to go down the pathway of breaking with an element of tradition in that regard. But he didn't manage to really explain to the House, and perhaps the next Speaker for the government might like to just put on the record of the House why the difference between civil pecuniary penalties and criminal penalties, because and the example that's used in this particular article by Chapman Tripp, which I do think is worth raising again, and I do hope that the government does respond to it. The point that they made is that the distinction between civil and criminal penalties may amount to nothing more than, I described it in the committee stages as dancing on the head of a pin. And the example that they give was a fine under Section 40 of the Fair Trading Act. That's a criminal penalty, but a fine under Section 80 of the Commerce Act is a civil penalty. And so why is one an opt-in and one an opt-out? And that's a very simple question, and I can see that the next speaker for the government is really excited about the opportunity of actually being able to respond to that question. He looks really set to explain to the House why it was decided that we would have on the civil penalty side, we would have a negative list approach. That is, they will be directly enforceable unless it's specifically excluded by Order in Council. And of course, the regulatory regime on criminal fines will be directly enforceable only if declared to be so by Order in Council. That's the positive list approach. So I really am looking forward to quite a major contribution to the advancement of the law by the government, stating for the record why the difference between the two approaches, and I can just see the member opposite is really looking forward to taking up that opportunity. The other question that I asked the Minister during the committee stages was this question about the difference in law, and I did say that on both sides of the Tasman. So, and that was the question of whether the regulatory regimes themselves having some maybe nuanced differences in some instances, but actually major differences in others between some of our competition laws in particular, whether it was going to be really the situation that by de facto operation of this arrangement, the Australian law will apply in New Zealand and vice versa. And I think that that's a really good point to raise. And I don't, as I said in the committee stages, I don't necessarily agree with the proposition that Chapman-Tripp are putting forward here. I actually personally think that there are reasons for having different approaches on regulatory regimes, and sometimes a stepping stone to a more coordinated and mutual regime is actually having the enforcement recognition that we have under this Trans-Tasman Proceedings Bill. So I'm not completely struck on the argument, but I really would like the government to put on the record why they've adopted this particular approach in order for those that take a great interest in these matters, and I'm sure the legal profession who will be utilising this legislation at some stage in the future will look back at the contribution of various members to this debate, and I know that they will look most interestingly at Chester Borrows's contribution, because they know, and the courts might be looking as well, if there's any doubt, they will be looking at what the history behind this was, what the government's thinking was, and Chester Borrows, as the chair of the Select Committee, I know is all over the detail of this and will be able to explain to us, for example, whether the New Zealand Commerce Commission is unlikely to accept arguments that a New Zealand penalty should be reduced to take account of penalties imposed in Australia in respect of the same or related conduct, and likewise for the Australian Securities and Investment Commission. Was that at the forefront of the government's mind in its thinking around the adoption of the particular form of legislation? We heard in the committee stages also about the changes that were made by the Select Committee, indeed adopting a purpose clause in line with the Australian legislation that has been recently passed as well. And I commend the Select Committee for an excellent piece of work, and that's why I'm looking forward to the contribution from the Chair of the Select Committee in that regard. I thought I would close with reference to David Goddard QC, who I know that my colleague Charles Chabelle mentioned in his first reading speech. This is also mentioned in the article I referred to at the beginning of my contribution. He was a member of the Trans-Tasman Working Group, and he described the changes as the minimum level of coordination required to achieve the goals of reducing the cost of Trans-Tasman dispute resolution and enhancing the effectiveness of regulatory regimes. He concluded the significance of the reform should not be underestimated. They represented the furthest reaching such proposals between any two sovereign states with separate legal systems. That is an incredible endorsement of what we were able to achieve in government and what this government has been able to put in legislation. I commend the bill to the House.